Good morning, all. I'm here to discuss about case studies. First case study: Balfour versus Balfour. Facts: Mr. Balfour and his wife went to England for a vacation, and his wife became ill and needed medical attention. They made an agreement that Mrs. Balfour was to remain behind in England when the husband returned to Ceylon, and that Mr. Balfour would pay her €30 a month until he returned. This understanding was made while the relationship was fine. However, the relationship later soured. The lower court found out that there was sufficient consideration in the consent of Mrs. Balfour and thus found the contract binding, which Mr. Balfour appealed. Issue and decision. Issue: was Mr. Balfour offer indeed to be legally binding? Does the fact that they were husband and wife matter? Decision: Mr. Balfour's appeal was allowed. Reason: the law of contract is not made for personal family relationships. As there was no intent to be legally bounded when the agreement was agreed upon, there can no longer binding contract. That if the court were to allow all the wives to come to the court when agreement has been broken with their husbands, the court would have overrun with frivolous cases. In the result, they added that there was no bargaining of any kind made by Mrs. Balfour sufficient for binding a contract. Promise and spousal roles aren't legally binding. Second case study: Ramsgate Victoria Hotel versus Montefiore. Facts: the defendant, Mr. Montefiore, wanted to purchase shares in the company's complainant's hotel. He put in the offer to buy complainants and paid deposit to the bank account to buy them in June. This was for a certain price. He did not hear anything until 6 months later, when the offer was accepted and he received a letter of acceptance from the complainant. By this time, the value of shares had dropped and the defendant was no longer interested. Mr. Montefiore had not withdrawn his offer, but he did not go through with the sale. Issue: the complainant brought an action for specific performance of the contract against the defendant. The issue was whether there was a contract between the parties after the acceptance of the original offer 6 months after it was made. Decision: the court held that Ramsgate Victoria Hotel's action for specific performance was unsuccessful. The offer that the defendant had made back in June was no longer valid to form a contract. A reasonable period of time has passed and the offer had lapsed. The court stated that what would be classified as a reasonable time for an offer has to be lapsed would depend on the subject matter. In this case, it was decided that 6 months was the reasonable time before automatic expiration of the offer of shares. Yet, for another property, this would have been decided by the court in individual cases. Thank you.